Welcome, everyone. I'm very happy to have all of you here, even though I can't see all of you. I'm hoping that while I'm talking, you'll be able to just say a little something about yourself. Some of you have already started, where you're from, where you're zooming in from. Maybe a little bit about the organization you're with or the work you do, your name, anything that you feel comfortable sharing in the chat. That can just go on so that you can see each other while I begin the webinar. We have a very short amount of time together for a very complex area of women's human rights. So I want you to bear with me while I go through some what I hope will be helpful foundations for you, so that when you go back into your advocacy work, you can recall what some of the things are to look up and to follow up on, and maybe you can attend our future webinars and build on this. So if we go forward to the agenda, I'll just talk you through what you should be able to count on. So the next slide, please, Laksha. What you should be able to count on us covering today. So we're going to talk about what we call the herstory instead of the history of the protections for gender-based violence in CEDAW. We're going to skate over that fairly quickly just to give you a picture. We're going to get to know what some of those protections are, how to find them, and how to use them. And also a little bit of a kind of foundation in how to use international human rights to support your advocacy work. Now, I'm assuming that all of you have some interest in this, or you wouldn't have come. And some of you, therefore, must be using CEDAW quite a bit. You may be experts in using CEDAW, and some of you may be brand new to it. But I'd like you to just say to each other in the chat if this is new for you, if you've done it before, and specifically, have you worked with CEDAW before, and do you work in the area of gender-based violence against women? So just please feel free to throw any of that into the chat if you haven't already as part of your introduction. And that gives me an idea of how to speak about the protections and knowing what level of engagement you've already had. So if we could go to the next slide, Laksha. So I just want to talk a little bit about why we have a treaty that is specific to violence against, to discrimination against women. There are a number of international human rights protections that are general in nature and that technically apply to women. However, in a beautiful quote that I've put up for you by Kimberly Crenshaw, who summarizes this history quite well, that although the Universal Declaration for Human Rights in its own terms guarantees the enjoyment of human rights without gender distinction, it's clear that universalism did not actually apply to women because the lenses applied were very much focused on the human rights violations of men. And you can probably all imagine how those violations tend to be different. At the center of that difference, I would say, is the notion that human rights violations are about a man of conscience who has gone up against the state and who is perhaps unfairly imprisoned or persecuted for his political beliefs. When in truth and in fact, the largest number of human rights defenders in the world, around the world, are women who have had their rights violated by having violence committed against them. And very often that violence is in the domestic sphere. So women's experience of human rights violations at its core have to do with violence. So if we go to the next slide, we look at some of the law that has been put in place internationally. And that law has evolved largely from the advocacy that women have engaged in. And you'll see I have a 1993 bullet there highlighted because we don't have time today to go through all of these foundations. And So the convention itself that we're talking about, CEDAW, was adopted in 1979. It came into force in 1981. That's the first bullet on your slide. But if you go to the highlighted one, 1993, the UN World Conference on Human Rights in Vienna, this conference was really the culmination of the recognition of women's rights as human rights, so that this specific way in which women experience violations cross-cuts through all of the UN documents. And the reason for this is that women organized globally. And in fact, the Women's Human Rights Institute founder and director of research and policy and law is Alda Facio, who is one of the people who was involved in that very activism. So it's important for us to know that the relationship between women's movements and international human rights law is very live and has been live from the beginning. So what we discovered at the Vienna conference was that women around the globe had very different contexts for what wound up being quite a similar experience, which was that they were experiencing violence in all spheres of their life, private, public, and that this was not being recognized either by the laws in their country or by the international human rights system. And so I really want to emphasize that this initial process at the Vienna Tribunal, which is a women's rights tribunal that was organized by grassroots women's advocates and held in parallel space to the Vienna Conference, and then brought into the center of the Vienna Conference, with judges who sat on panels to listen to the testimony of women from around the globe about the violation of their human rights. And this is one of those judges. She said that she saw that the commonalities of violence across the globe really was the cornerstone for women's human rights protections. So it's not just that CEDAW protects against the violations, but it is a cornerstone of women's rights internationally. So if you can go to the next slide. I just want to talk to you a little bit about where this protection is anchored. So remember this when you're thinking about writing a submission. Let's say your country is going to be reviewed by CEDAW, and you want to write a parallel report that says, well, the state says they've done everything right, but I want to tell you what it's really like here in my country to be a woman who's trying to protect other women against violence against women. Where that protection in CEDAW is anchored, and this is important legally, is in Article 1. And Article 1 is the cornerstone article, what they call in international human rights law, the chapeau article, which is just French for the hat. So the hat goes over the whole treaty. And what this means is that discrimination is the violation that covers the whole treaty, and violence against women is in fact the cornerstone. And if we look at a definition of what is violence, violence is any act of gender-based violence that results in or is likely to result in any kind of harm or threat. So if you look at the definition fully described on your screen, that's how you define violence against women, which is called gender-based violence against women in international human rights law. So if we can follow through to the next slide. Vienna took the work of these founding mothers, and the United Nations Commission on Human Rights, which is the governing body for the human rights treaties, adopted a resolution in 1993 calling for the full integration of women's rights into the work of all human rights bodies and monitoring mechanisms. This is a very significant watershed in the protection against all forms of discrimination and all forms of human rights violations for women. So if we move forward to the next slide, we'll see that there are, in fact, 9 core international human rights instruments And each of these instruments has established a committee of experts to monitor the implementation of the treaty provisions by the state parties that have signed on to that particular treaty. And CEDAW is one of those 9 international human rights treaties. And I'm telling you this because the other treaty bodies can also be used. If we could go forward, Laksha. So there are protections against violence against women in a variety of international rights, human rights treaties, and under the protection normally against gender discrimination and the right to life, liberty, and security of the person. So you're not restricted to CEDAW, but it is the core protection set of protections because it is specific to gender. Yes, please go ahead. Thank you. So this is what I was starting to talk to you about just a few moments ago, that anchored in Article 1 of the Convention is the protection that CEDAW, the committee, where I told you that there were committees that interpret each of those treaties, each of those human rights treaties. Well, the committee has interpreted CEDAW to have protection against violence against women anchored in Article 1. So it sees violence that is directed against a woman because she is a woman, or that affects women disproportionately, and as such, that is a violation of their human rights. It's a form of discrimination. So discrimination in the treaty means any kind of distinction, exclusion, or restriction that's made on the basis of sex. Now I'm going to pause there because in the 1979 language, sex was the word that was used, but the treaty has really understood that to mean gender. So those of us who've been in the field for a long time understand that distinction. So it's important for you to read the word sex in the treaty as a concept of gender. This is the definition of gender-based violence against women that the committee now uses in terms of why it is a violation of women's right to live free from discrimination. And I'm not going to read it out to you. You can see it there, but essentially it is a very broad definition. And importantly, it sees violence against women as an obstacle to achieving substantive equality between women and men, and that it interrupts women's ability to enjoy any of their other human rights and fundamental freedoms. So this is really seeing violence against women as a cornerstone of discrimination. It is one of the main drivers of discrimination. It both exemplifies it and it increases it. So it's important then to know that those treaty committees, I'm going to describe them a little bit for you so that you understand their role in your advocacy. The treaty committees are made up of independent experts. So they're not, although they come from a variety of states and they may be nominated by their state, technically their role is to be independent of their own state's practices. And in fact, they are unable, if they're from, let's say, I was on CEDAW and I'm from Canada, I could not review Canada because it would be seen as a conflict of interest. So that treaty committee plays a role as an authority on the interpretation of the treaty. But it also has to keep those state parties who are parties to the treaty in the conversation. So it has to encourage them to fulfill the obligations. And the committee's pronouncements on the proper interpretation of the treaty play almost a quasi-judicial role. So almost like a judge saying, this is the meaning of the law. I have the authority to tell you what the meaning of the law is. And they create a kind of human rights jurisprudence. So, but the ultimate legal authority that binds states is one of mutual agreement between the states themselves. So that is the human rights treaty system. It's not unique to CEDAW. It's the same for all of the UN mechanisms. The ultimate authority, unless you're into international criminal law, the ultimate authority is the states themselves holding each other and themselves accountable. And this is sometimes what is often confusing for people who compare national legal systems to international legal systems. So I just wanted to give you that clarity so that you, when you're doing your advocacy, understand the role it plays. Your state has a legal obligation if it's signed on to any of those treaties. But beyond that, we will talk in a moment about its obligation around violence against women. So the way that the committee makes up its interpretation is a combination of the language of the article in question. So any articles that you want to quote and say, I think my state violated the article that talks about access to education, for instance, then you compare that to the general recommendations, which are basically the interpretations of the treaty that the committee has made, and they're publicly available, and what are called concluding observations. And those are the pronouncements that the treaty body makes when a country is being reviewed, and the case law, which is individual complaints that might come to CEDAW under certain circumstances, or when they've done a review of a country. Okay, so if we could move on, then we see that state obligation to protect against gender-based violence against women is particularly anchored. If you could only read two general recommendations, I would recommend that you read General Recommendation 19 and its update, which is much more recent, which is General Recommendation number 35. So if we move forward, I'm going to take you through a little bit of the definitions that came out of those two interpretations of CEDAW that really spell out what it means to CEDAW to be a state, for a state to have to protect those within its borders against gender-based violence. And specifically, General Recommendation 19, which came out in 1992, said that states must take all appropriate measures to realize this right and this obligation. So this is really important because a state has to marshal within its capacity everything it can to fulfill this obligation. Now, how many of our states actually spend the kind of money they need to tackle this matter, which is, as the UN has declared it, a global pandemic? Violence against women is a global pandemic. Long before we had COVID in 2013, the UN declared it a global pandemic. So it has both public health and human rights implications, and the states mostly don't marshal the kinds of resources they can and should to tackle this issue. So this is an important aspect of their obligation that I really want to draw your attention to. If we move on, Laksha, CEDAW has a very, I would say, wide view of what women's rights are and what the protections are. So in implementation, they say, is key to guaranteeing that women and girls have a life free from gender-based violence. And that is through addressing the underlying elements of gender discrimination that make women vulnerable to violence. So if you think about what does that mean? So that means instead of just saying, oh, we have to have some shelters so that women can run to a shelter in the moment when they're experiencing violence, that's not all the state has to do. Yes, it has to do that, but the state also has to prevent women from experiencing violence. So there are broader equality aims that the state has to fulfill in order to actually fulfill its obligation to protect women against gender-based violence. So when you think about all the factors that drive women into violent situations that make them more vulnerable to violence, we'll walk through some of what those are, and CEDAW names them. So if we go forward, specifically in General Recommendation 35, which you will remember is the updated version of the first time they pronounced on the role of violence against women in the overall discrimination against women and girls. You look at paragraph 9 of General Recommendation 35, and you have a very clear definition that violence is a social rather than an individual problem. So this is an important feminist principle, that it's not my problem, my psychological problem, that I got involved with someone who was violent. It is a social problem that affects the majority or a large minority of women, and that it's everyone's issue, and that it is ingrained in how our societies are set up. And we use the word intersectional a lot more these days. And it's important to know that CEDAW has really interpreted its articles through the lens of intersectionality. So it's a very live, living document that has really adjusted to the language that is important in feminist activism. And in fact, they had Kimberly Crenshaw, who is credited with coining the term intersectionality. She's an American critical race feminist. And they actually had her to come and do training at the UN, which is why I have some of her quotes sprinkled throughout here. And she says that intersectionality specifically addresses the manner in which racism, patriarchy, class oppression, and other discriminatory systems create background inequalities that structure the relative positions of women, races, ethnicities, classes, and the like. And why is this really important? It's important because a state can't just say, oh, well, we had a crisis and a bad thing happened, but it's over now. A state has to look at the ways in which the social organization that they have overseen and supported has led to the crisis. And then they have to put in place structures that will lead us out of the crisis. So this is a really important aspect of how discrimination, when I say crisis, I'm talking about a crisis of discrimination. So if we go forward, Laksha, I would like to take you through some of the ways in which CEDAW has really articulated the intersectional protections within the treaty as a whole. And again, we're using General Recommendation 35 because it is the authoritative interpretation from the committee itself of what the treaty means. So in paragraphs 12 through 28, and I'm giving you these paragraphs because I'm hoping when you are drafting things to take to the UN or to tell your government, local, I don't care if it's municipal, provincial, federal, national, whatever government you are taking this to, or if you're taking it to the UN itself when your country's undergoing a review, these are the paragraphs you want to make sure you cite in your writing, because it really anchors your claim. So discrimination against women, they say, is inextricably linked to other factors that affect their lives. And if you look at this list of things that CEDAW has cited, this is clearly a list of intersectional elements. So if you want to go forward, please, Laksha. So these are the protections that are listed in General Recommendation 35 that ensure that being lesbian, bisexual, transgender, or intersex is not grounds for discrimination. Illiteracy, trafficking in women, these are all conditions of discrimination that lead to further violence. If you could go forward. The context of armed conflict, seeking asylum, being a refugee, heading up households, widowhood, living with HIV/AIDS, geographical remoteness, stigmatization of women who fight for their rights, including human rights defenders. These are all elements of the intersectional nature of what makes women more vulnerable to violence and what states have to guard against. So, what are the sources of protection against gender-based violence against women? So we've gone through some of the elements that have been named in what I call the jurisprudence of CEDAW, but they also exist in many other places. So really anchoring all of this is the knowledge that 189 state parties have signed on to CEDAW. Now, some of them have entered, they've entered what we would call sort of conditional signing. So they've said, oh, well, we have objections to this article or that article. But the fact of the matter is, once they've signed the treaty, no matter how many times they say they object to something, they have signed on to the obligation. That is the kind of net, complicated legal argument result. And General Recommendation 35 states that the prohibition against gender-based violence against women has evolved into a matter of customary international law. Well, what does that mean? So I want to explain this to you because it's extremely important, especially if your country has not been one of the ones to ratify CEDAW, like the United States or Sudan. What it means is that even if your state has not signed on to CEDAW specifically, it is now considered a matter of customary international law that states are obliged to protect those within their borders from gender-based violence against women. So there are some what we would call non-derogable rights, some things that cannot be abdicated from by a state, even if they have not signed any of the treaties. It is a matter of what's called customary law, that if you are a state, you are obliged to do this, regardless of any of your other leanings or any of your other obligations. And this is really important for us to know as feminist advocates, because often your state will say, oh, well, they don't have any authority over me. It's an international treaty. We have our own protections. We have our own national system. But this is a matter of international customary law. And it's important for us to hold our states accountable. So let's move forward. So there are other conditions under which this state protection is advanced, and individuals can be held accountable to the international community directly. And those are in cases where a state has been convicted of any kind of international human rights crime related to gender-based violence. And it can amount, gender-based violence against women can amount to torture, cruel, inhuman, or degrading treatment in certain circumstances, and including in cases of domestic violence, or harmful customary practices, various forms of gender mutilation, those sorts of things can all be contained under this notion of torture or cruel or inhuman or degrading treatment. And as I just mentioned, some forms of gender-based violence may also constitute international human rights crimes. So the CEDAW committee mechanisms are ways for us to get involved in international human rights protections and advocacy, and to hold our state accountable. So there are different points of touchdown for advocates, and I'm not going to spend a lot of time on all of them because in the interest of the time we have together. But state reporting is one that I really want to focus on. So there are 3: state reporting, what's called individual communications, and inquiry. And I will touch on the last 2, but I really want to focus a little bit on the first one, because this is the easiest one for us to engage in. So there is a lot of information that you can get on the UN websites. And I think Angela has put some of the links in the chat for you. And what I'd like to say is that the cycle of state reporting, often for advocates, and some of you who are here may know this, we focus on the every 4-year cycle when our state is coming up for reporting on its obligations under the treaty. And typically what the committee does is it says, okay, well, last time we issued you this set of recommendations. Now we have a set of questions in between that we're going to send you for you to answer for the next reporting cycle. And that at the next reporting cycle, you come as a state, come and tell us, what have you done on these things? These specific questions, we want to know an answer to. And typically, as advocates, we would rush off to create our alternate, and we would our alternate report on what the state has done, and we would send that, either send it or we would go with it and present it at the UN. And then we wait 4 years and do it again. What we really should be doing, and what is most effective, is engaging between those cycles, those 4-year cycles, and using that same cycle to keep the state accountable through all the advocacy we do. And likewise, we should be engaging with our advocates that we work with, gathering information, seeing fairly where the state has made progress and where the state has not made progress, and following that so that we're engaged in the full cycle for the full 4 years. So if we can go forward, Laksha. I also want to draw your attention to other mechanisms that we can appeal to, specifically around violence against women. And there are various what are called special procedures, and special procedures actually describes people and committees that are mechanisms for us to access when we are concerned that human rights violations are happening. So there is the Special Rapporteur on Violence Against Women, its causes and consequences. And again, this Special Rapporteur exists because of feminist advocacy. Feminists petitioned the UN and made a very strong case for the institution of this Special Rapporteur. And in the upper left corner of those photographs is the current Special Rapporteur. The Special Rapporteur on the Rights of Persons with Disabilities has a very gender-forward mandate, and I would like to draw your attention to her. She's on the right with the blue jacket, and then the Working Group on Discrimination Against Women and Girls, which is at the bottom, and you'll see in the center of that Alda Facio, who will be giving some seminars in this series just a little bit ahead of the next few months. And Alda was the chair of this committee and a member of it up until very recently. So going forward, there are also regional human rights protections. And I'm not going to go through all of those, but each region has its own set of human rights protections, which are nuanced and contextual. They are supposed to respond to the conditions, the cultures, and the specific contexts of the regions that they're in. This woman is holding up a sign that talks about the Maputo Protocol, which is violence against women protection for the African region. Okay. So within nations, like that is, aside from the state cycle, when we're at home, how can we use this? Let's say we're not ready to engage with the UN system. I think it's very important for us to understand that women's human rights exist, that they are international, that they are obligations that our state has, and particularly that gender-based violence is a matter of customary international law. And we can talk about this even when we're delivering groups, let's say, with women who've experienced violence. I have been a direct service worker in the context of Canada with women who have access to very little. And it is very empowering for them, has been in my experience, to talk about that women around the world experience these things and that these are actually considered acts that the state is responsible to protect us against. This is really, really quite powerful information for most people. So I like to talk about us all being part of an international movement against gender-based violence, no matter where we're located. You don't have to be a fancy lawyer to know that these are the things that protect us. So you can support staff in your organization this way. Often we feel when we're doing frontline work that we are, we're constantly hearing the worst stories. And we don't get a lot of respect and credit for doing that work. So I like to talk about how we are all part of a global network of human rights defenders. So remember at the beginning, I talked about how human rights was seen as sort of in a male dominated way, that you had to be like, strong advocate in the newspaper, fighting the state, maybe, put in jail because of your beliefs. But in fact, women are human rights defenders every day when they try and protect themselves against violence, when they try and tell their communities that their partner is hurting them and they need assistance, or that they won't put up with it anymore, or they even just protect themselves by coming to a shelter. They are part of an international network of human rights defenders. And that changes a little bit the way we see ourselves and each other. We're not victims. We are part of an international movement to defend our human rights. We can use these international protections in our representations to parliamentary committees, to government bodies, to policymakers, when we write our reports on projects that we've been funded to do. And we can start, by saying, hey, listen, our state signed on to this treaty and it's not respecting it in this and such way. We can, of course, as I was talking about earlier, make representations to various human rights treaty bodies, and we can make representations to what is called the Universal Periodic Review. We don't have time to go into it now. I'm hoping we'll talk about it in the future, in some of our future seminars. But it is another mechanism at the UN where states come together to review the overall performance of each other and whether a state has been living up to its expectations on human rights for all of those 9 treaties that I told you about, not just CEDAW. And I can tell you that in my advocacy, I had some very useful recommendations come back to Canada on the need to create a national action plan on violence against women, because I lobbied the other states at the UPR process to tell Canada to do it. And sometimes, you know how it is with your kids, like sometimes if their peers tell them to do something, it has more power than if you tell them. That's kind of what the UPR system can be sometimes. Then you can make representations to the CEDAW committee directly, and you can use the special rapporteurs, as we discussed earlier. So at the end of Vienna, there's a beautiful film that I hope you get a chance to watch at some point that traces the road to Vienna that the grassroots women's movement made to get us all our international human rights. And at the end of that film, this was what was on the screen. There is still much work ahead. And it was true then, and it's true now. So mostly, I want you to remember that CEDAW is a tool for us. It was created because of feminist advocacy. It is shaped by feminist advocacy. And the more we use it, the more it becomes the language of how states will hold each other accountable and how we will be able to hold them to account. And it's because of advocates who worked on the issue of gender-based violence that we have these tools in the first place. I believe it's a powerful tool that's ready to hand. And it was fashioned by the hard work of feminist advocates who came before, right through to the Universal Declaration. So some of the resources that I hope you'll be able to make use of if you do decide to pursue this as a form of engagement with your advocacy. And if you go to the next slide, I've actually pointed you also to some of the things to quote in your materials that take you to where gender-based violence against women is prohibited and where state obligations are articulated. And these are things that you can use that I'm sharing with you. And I think that's it. And I think, Angela, you've been keeping track of some questions for me. So I would be really thankful if you would take me there.
Great, thank you so much, Amanda. We had a couple questions and I replied to the chat, but I'll just simply mention that this is being recorded and we will share a recording with you. There were some requests for the PowerPoint. We don't usually send out the PowerPoints, but you'll be able to see that in the video and access that'll be publicly available. So we will send that out after. So that's a simple question. Then we've got a couple questions. The first one is, I'll just read it out to you. Asking if you can elaborate on competing interests in cases of domestic or interpersonal violence when arrests are mandatory. This type of policy is justice sensitive, but they're asking, is it victim or survivor centered? So what trumps in this case, a justice sensitive approach that seeks to end impunity, or a victim survivor centered approach where the consent of the victim / survivor who may not cooperate when arrests are mandatory is fundamental. So asking, what do the international norms and jurisprudence recommend?
Okay, it's an excellent question. And it's something we're struggling with in the Canadian context, of course, since we had mandatory charging implemented about 30 years ago. You could say it was better than what went before, because there were no charges laid against abusers, and it was considered a man's right to to beat a woman who he lived with, usually either a common law spouse or a married partner. In the intervening 30 years, we've seen, of course, the application of that be quite differential depending on race, depending on economic status, etc. So I guess my answer is that the international norms are that the state has an obligation to ensure that there isn't impunity in general, but there aren't general applications of how that should be applied in every circumstance. So there are guidelines, there are sort of promising practices, there are general recommendations that look at access to justice, for instance, that describe the state obligation to ensure that women have access to legal information, to legal advice, and to legal protection. But in terms of how each state and each context would nuance that for their particular situation, it would intersect with that notion that differential application of the law is also not a good thing. So if you have a highly racist society where policing is, enacting violence against communities of color, Black, Indigenous communities, and you're forcing women into that system, so Black and Indigenous women are having a different experience of state protection, is no longer protection, it's actually part of the violation, then CEDAW would recognize that in terms of its own, you could make that argument in terms of its own understanding of what intersectional protection means. So I hope I answered that question. Any other questions, Angela?
Yeah, thank you, Amanda. Next question. We have one question that's about specific litigation. I might actually, I'll come back to your question, Wale. I know Waleska put that question in. Maybe I'll first start with, we have from Aja. Are you aware of any instances where CEDAW has been cited or referenced at a more local level, i.e. municipal or territorial, that has resulted in meaningful, formal, and or substantive equality change?
It's a great question, Aja. And I'm actually going to ask Angela to talk about a project that she knows a lot better than I do, which is a CEDAW-based municipal project.
Yeah, in fact, we have somebody, if I scroll up in the chat earlier, from the US who referenced being part of one of those municipal ordinances. I'm sorry, I'm scrolling to see, but I can share some links in the chat around that. But in the example of the United States, which is one of the few countries in the world that has not actually ratified CEDAW, where there's no federal ratification, a movement was created that started in San Francisco and has spread to really implement CEDAW from the municipal level up to try to make that movement happen in kind of the opposite direction that it sometimes happens, even though a municipality cannot ratify CEDAW at the international level because they don't have a standing of the state. What was done was at the municipal level, creating ordinances that actually brought CEDAW into, municipal policy and practice. So there's a whole website and a lot of fantastic information about doing that in that kind of grassroots movement. And there have been some other movements, not necessarily focused only on CEDAW around the world, to create what are called human rights cities, for example, where at the city level, treaties or human rights principles are taken on again, through a statement of principles or through, a city ordinance and so on, to really bring that in, to create those guidelines to inform indicators on gender equality or approach policies on violence and so on and so forth. So there are a lot of creative ways that people are picking up CEDAW that is, separate and aside from actually what happens directly at the UN. And we really strongly encourage that. And of course, many organizations do that work also in their own analysis, their own advocacy and lobbying with their own governments. They use CEDAW as a framework to develop an analysis of, where the failure of state obligations are to push for that change, whether it's at the municipal level. We had once a participant who came through our course from Mexico, who went back home and developed in a local rural area a kind of a policy statement with women's organizations and leaders on what the failures were to support women's rights at the municipal level. And that became a document that they built on dialogue with the local government. So, but yeah.
And Terry, I see Terry has put in the chat Cities for CEDAW. So that's something for you to look up, Asia. I see Asia has a follow-up question regarding the special rapporteur's discussion of the special rapporteur on violence against women visited Canada, did a report, and talked about the failure to implement so many of the recommendations that have come its way, and to meaningfully interrupt the cycles of violence that women in Canada experience, particularly Indigenous women. And she talked about the fragmented nature of the legal system here. And so Asia's question is there any impetus for Canada to harmonize the laws? Well, Asia, you might know that we just recently submitted in the last year a framework for a national action plan on violence against women. And one of the appendices in that 400+ page report, which I was lead author on, has a substantive paper on the different forms and levels of law that women have to engage with if they are trying to protect themselves against violence. And what we suggested was that we raise to the highest level of those laws, the highest level of protection that those laws offer, all of the other, we incentivize all of the other levels of government to rise to that level. So in the Canadian federated context, which other federated states would be similar to, it's hard for the national government to impose a standard because of the autonomy of the provincial governments. But often it hides behind this and doesn't lead the way. And so our advice is to incentivize the national government to lead the way, and then to really shine a light on the best laws that the provincial or state governments are enacting, and have sort of lead by flattery to get the other provinces or states or jurisdictions to rise to that level. And that has been an initiative that we have been behind. Are there other questions, Angela, that I've missed?
Yeah, so I'd like to come back to Waleska's question, which was to ask if it would be possible to share some landmark cases on GBV and femicide, besides the very famous Cottonfield case that could be used for litigation at the domestic level.
So it depends on your domestic context, what can be used at the domestic level. It's a very complex question you've asked. So I wouldn't pretend to know kind of the legal traditions of every country in the world and what is admissible and what forms precedent. But certainly, if you're looking for international standards, you would do well to review some of the individual communications that CEDAW has produced. And I noticed that somebody else was asking about sexual assault and whether that gets left behind in the discussion of gender-based violence. And certainly CEDAW, I would say its two principal areas of jurisprudence are in sexual assault and state response to sexual assault. And it has extremely good cases on this, and on domestic violence and state failure to protect. So what's called case law at the international level comes about when an individual seeks remedy in their own state and is failed by that. But you have to pursue, as an individual, you would have to pursue every available means to rectify your situation within your national context. And once you've what they call exhausted domestic remedies, you can make a direct complaint to CEDAW that your rights have been violated under the treaty's terms. And those cases, they take a while to work their way through the system, not as long as some national legal systems, I might add, but they do take a few years. And often those findings are extremely strongly worded and very precise about what's missing in the response, let's say, to sexual assault. There's an excellent case on the Philippines where a judge was completely out of line in her decision about a sexual assault case and the kinds of things she said to the complainant. But these are things we see all over the world in all kinds of legal systems. It's very useful language to come back to your state with about how those decisions should be made. Similarly for domestic violence. One of the cases that CEDAW found on very early was a case in Hungary. And in that case, they stated unequivocally that the right to privacy does not trump the right to protection from violence. That the right to protection from violence is a far stronger and more ingrained right than, because it goes to the heart of the human rights system, the security of the person, et cetera, that the right to privacy does not trump that right. And that's a really important finding in that case, because you can use that in your local context to say the international standard is this, and often states still are saying, oh, but it's a private matter and we have no business dealing with it. Well, CEDAW is very express about that in the case law. Okay, anything else, Angela, that you need me to pay some attention to?
Yeah, there's a few additional questions. One is from Mariana. Here in Latin America, we don't use CEDAW as much as the Inter-American Convention Against Violence Against Women. From a feminist lawyer perspective, this is due to the difficulty to access the universal system for individuals. So do you have any recommendations for Latin American activists to take more advantage of CEDAW and what to do about the monetary expense to take cases to the CEDAW committee?
So I think in some ways, COVID's your friend in this, that you don't actually have to go to Geneva anymore to have access to the CEDAW committee. And you can make representations. Many representations are made online anyway. And certainly the filing and the lodging of any of your cases would be able to be done online. You have a very strong system in the Latin American region, and you have some of the best wording on violence against women protections. In fact, Canadian Indigenous women have used that system over many other systems, including our national system here in Canada, in order to gain some recognition of the violations that they've experienced. So you have a strong system. It would depend on your motivation and reasoning for going to the CEDAW committee for specific things. I would encourage you to follow up with the CDAW committee, and you have a good Latin American representative on the committee, to find out what kinds of conditions and situations strategically might be the best for individual claimants who are not getting the kinds of results that you want in the inter-American system. But generally speaking, because you have a specific protocol on violence against women in that region, one that I have been encouraging our government to sign on to, I think you're operating in a strong context, and I appreciate that. That's why you are using it.
And if I may, I might just add that, Amanda earlier in her presentation talked about, the special procedures, the treaty bodies, the UPR. Like, there's so many different mechanisms within the UN. Maybe I'm understanding, Mariana, that your interest is like an individual case, which would be under the optional protocol to CDAW to really file it in a more formal way. But there's also nothing preventing you from looking from a broader advocacy perspective to say, okay, maybe we don't have the time or the money or the patience to wait all of the years for an optional protocol case. Maybe we just want to submit an urgent communication to the UN Special Rapporteur on Violence Against Women, asking her to investigate the matter, which wouldn't create the same kind of binding recommendations, but at the same time gives you, like a press release, a communication that goes to your government, that you can build an advocacy structure around. So part of what's really important to understand with the women's human rights mechanisms available is the strengths, the limitations of each, and how you can sort of use them in relationship to one another, which we can't maybe get into all the ins and outs of that today, but there are ways to kind of get attention to things, for example, through the special procedures more quickly and so on. I hope that's helpful. And in our courses, we try to go more deeply into, how to look at those mechanisms in relation to each other. We have a few more questions. Are you good with a few more questions, Amanda?
Absolutely.
Yeah. Okay, so we had a question that was, from a bit of a kind of a different entry point, and it's asking, how does CDAW reach those victims who are silently abused and tortured in their homes, who don't have access or, access to help? And I think this is part of the question of also understanding, like, what is the most effective way that we can use these, when can we, and so on. So I'll shift that question to you.
Yes. So your question really goes to, what difference does it make? What difference does it make to have these protections when so many women are locked up with abusers without access to any means of communicating the nature of the oppression that they're experiencing? And they may not have the means to, to gain the kind of support they need. And my answer to you is that there is no connection except us. Unless we use these mechanisms to advocate within our own contexts, that silence can continue, and that oppression that's unrecognized can continue. Our governments have to be held to account for a general condition in the society that doesn't undermine women's equality, that in fact proactively promotes women's equality, and by doing so alleviates all of the pressures that make women more vulnerable to violence. This is not an optional thing. You can't address one without the other. This is a very clear obligation under CDAW. And it has what we call in law positive obligations. So it's not just that the government is required to prevent a bad thing from happening once it's happened, or to respond to a bad thing once it's happened. It's not just that you need a fair court system for a survivor to go to. You also need to put in place the things that will prevent her from experiencing that in the first place. So in terms of each individual woman who experiences that oppression, she's not going to carry CDAW down to the local police station, and say, this is the protection I need. Well, although she could, in fact. But it is up to us to use, as advocates and as those who've experienced violence, as survivors who are advocates, to use those tools to require change wherever we are located. So we may not ask the whole government for a whole big change. We may ask for a small change that's related to the provision of, legal support in my community. Or it may be related to ensuring that there's a shelter. It may be related to a public awareness campaign that violence against women is not okay or is illegal. So it's not a direct relationship in the sense that, CEDAW is a piece of paper. It's not a shelter. It's not housing. It's not police protection, but it asks governments to do all those things under an obligation. So that's really what we're working with. I hope that got to the heart of your question. Are there any other questions, Angela?
And yeah, I responded to one in the chat, which was about the US context. So I did respond in the chat, but it might just be worth saying that for states that have not ratified CEDAW, which there are not that many anymore, of course, if the convention has not been ratified, there's no reporting cycle. So CEDAW can't be used in that way. But there are some other mechanisms that have jurisdiction over all member states, in a sense, which is the Universal Periodic Review of the Human Rights Council. All UN member states are reviewed through that UPR review. And as Amanda mentioned, that's a peer-to-peer state review process, but that's a space for advocacy for if you live in a state that has not ratified CEDAW. And the UN special procedures also have the mandate for all UN member states. So they can receive communications about cases in the US, for example, and so on.
And the business that I discussed earlier about the state obligation to protect against gender-based violence against women evolving into a matter of customary international law is also worth paying some attention to, because even without signing or ratifying CEDAW, that obligation remains. And the more education I think we have about that and that obligation, the fewer objections the state can then have to signing CEDAW in the first place. Because if they're hoping to escape any kind of international accountability for not doing things, then it's not going to work on this issue, because it has become a matter of international customary law that states have an obligation, just as they have an obligation to prevent torture, to prevent slavery. There's a list of kind of those things that all states, just by the virtue of being a state, have an obligation to protect against, and violence against women has now evolved into one of those things.
Yeah, and I think it's important, and we often end up discussing this in our courses. People often express a frustration with the limitations of the UN mechanisms, or the fact that the concluding observations from CEDAW are, they are legally binding, but how legally binding are they? And we try to come in from a bit of a different entry point, I think, at times, because of course states will always try to minimize their obligations or their interpretations, but our role as advocates is to really feel in our advocacy, in the way that we pick up the framework of the convention, use it for analysis, hold the government accountable, to understand that human rights should be looked at from a more expansive viewpoint, right? That really have to do with changing society. And so if we stay on the focus, like often people will say, well, but there's no mechanism to force the state, to comply. And then, how would we force the state, right? This is not a system where there is an army that's going to invade a state and make change. And when you say it that way, you realize, yeah, that's not actually what we want at all. So the norm building process, the dialogue process that happens, the way that we use our advocacy to really highlight these obligations to do even sometimes better analysis, right, than our governments do, is a way to kind of build over time. So it's not going to always respond to each individual acute scenario in the way that we would like to see change, but this is sort of a longer term project of how we start to shift norms in our conversations. And as advocates, we are the ones who have the opportunity to take that feminist activist perspective and feel, you know, really empowered to use those human rights norms to amplify the way that we address these issues. And so CEDAW has, you know, even though the optional protocol and the sort of allure of taking an individual complaint is very strong, you have to really look at what are your objectives and, you know, and understand how to leverage different ways of using the system, and also help define the system and help define the analysis. I don't know if you want to add anything to that, Amanda, but I think
that was brilliantly put, Angela. It was exactly the right response. And I think that contextual understanding, if you look at CEDAW, if you read it from top to bottom, it really is a recipe for a feminist future. And when you then put it in dialogue with its own interpretations, the interpretations that the committee has made and the elaborations on each of those articles and what they actually require, it is, I think, what most of us have been working as advocates for. It's the public policy reality that needs to happen if you're going to have a truly equal world where women can live free from violence and engage in the civic process on an equal footing with men. And that is really how to look at the whole package and use it to shape the demands you make, as Angela has so eloquently put it.
Thank you, Amanda. So I think we're coming close to our time for today. So I think we've addressed the bulk of the questions, if not full detail, all of them that we can't fully get to today. So before we wrap up for today, I would just like to take this opportunity to thank Amanda for your insight. I love listening to you. You know, the clarity with which you distill down what can be pretty complicated ideas to make them accessible. That's really important to us here at the Women's Human Rights Institute. We don't see human rights as being something that should be obscured or difficult to understand. But of course, we know in practice, navigating all of these systems, there is a bit of a learning curve. So thank you for drawing on all of your extensive knowledge and history to really break this down into some building blocks. I hope that that was helpful for everybody here today, wherever you are in your journey with CEDAW and human rights, whether you know quite a bit already or this was something new to you. Hopefully you've been able to take away some key ideas. I would also just like to add that I said this at the beginning, but this is the first webinar in a series of roughly monthly webinars that we're going to be doing. The next webinar date is not finalized, but it will be towards the end of August. We'll be inviting different speakers. We'll have some panel presentations or some individual speakers in this series, but the idea is really for us to kind of weave this thread to look through multiple entry points at how we can use CEDAW for advocacy purposes and really understand what's at the heart of CEDAW. So the next session will be looking more at CEDAW in situations of crisis and conflict. We have a subsequent webinar that's going to be focused more on climate change and environmental catastrophe and understanding that in relation to CEDAW and a human rights lens, as well as others. So if you haven't done so already, I would suggest you sign up for our newsletter. I put the link in the chat. I'll put it again. We'll send it out to you by email afterwards. It's the easiest way to keep in touch with us or follow us on Facebook. Thank you so much to everybody who's here. I see a lot of familiar names, partners, past alumni, people that we maybe haven't yet had the opportunity to meet with. So welcome if it was your first time attending one of the Women's Human Rights Institute's events. Yeah, we look forward to the next webinar, and thank you very much, Amanda, and Laksha, who's in the background doing the tech support. Thank you, Laksha, for all of your work to make the webinar happen. Great, thank you so much, everybody.
Thanks, everyone. Bye-bye. Thank you, Amanda.